Afternoon good afternoon, and thank you for joining the Peace Officer Decertification Q&A session today. I am Christine Ford, Bureau Chief from the Professional Conduct Southern Bureau, and I will be your moderator today. Before I introduce the panel, I wanted to cover a few things. We will be answering questions that were submitted to post ahead of time and answering live questions via the chat feature. If you choose to ask a question through the chat, please do not mention any names or agency names. We will answer as many questions as we can within the 1 hour time that we have. I would like to now introduce law enforcement consultants that will be sitting on the panel today. Brandon Kiley from the Professional Conduct Northern Bureau, Kevin Sherburne from the Professional Conduct Central Bureau, Bill Emboden from the Professional Conduct LA County Bureau, and Marcus Gregory from the Professional Conduct Southern Bureau. We will also have Bureau Chief Michelle Weiler from the Certification Bureau, Manager Holly Kinney from the Intake and Disposition Bureau, and Attorney Chris Becker and Toby Darden from Legal Affairs Bureau, available to answer any questions. Okay, so let's get started with the first question, which will come to Brandon. If I was issued discipline from my agency for misconduct and retained my job, can Post still try to decertify me?
Yes, if it's a matter related to serious misconduct, and the definition and the categories of serious misconduct are identified in Commission Regulation 1205. And we'll throw out a regulation maybe quite a bit during this presentation. So if you want to do a simple Google search and just type in California Post Commission Regulation, that'll take you to a link on our website. And just scroll down there to Article 4, and that will bring up every regulation that's associated with certification.
Okay, thank you. Marcus, I'll ask you the next question. Are agencies required to notify officers when they submit a case to Post?
There's no language in SB 2 that requires an agency to notify that their case has been submitted to Post. Agencies are taking it upon themselves to notify Post or to notify the officer if in fact they do send an investigation over. But there's nothing requiring the agency to notify the officer.
Okay, Bill. Next question is, how do you decide on what egregious is when you are looking at the allegation of acts that violate the law?
So there's no specific definition of what egregious would be. It's taken on a case-by-case basis. Examples would be, were there any injuries? Was the act repeated? How many times was it repeated? Was the public safety and welfare at risk because of the act? Does the officer have a history of misconduct and not conforming to a discipline or training? Things like that are taken into account on a case-by-case basis to make that decision.
Okay, thank you. Kevin? How many cases are making it to the decertification stage in comparison to how many cases Post is receiving? Mike.
To put it into context, Post has received approximately 35,000 reports of serious misconduct. All of this information is on the post.ca.gov website. And you can see that of those 35,000, what Post staff have reported to the commission and to the board are that Post is engaged in approximately 400 regulatory actions. A regulatory action for what I'm talking about today runs the gamut from anything from immediate temporary suspension in ITS to a full revocation, suspension of a license by the commission, or a disqualification. And that disqualification would be pursuant to California Government Code 1029. So what we've seen is that approximately 5% of the cases that come into us are sustained at an agency level of some kind of a policy violation. There's some sustained finding. And so I can't put an exact percentage on it, but roughly 5%, somewhere less than 5% of those 35,000 would be, according to those figures that we have to date, roughly speaking, would be subject to a decertification action.
Okay. Brandon, if I receive notification from Post that they want to talk to me about a case, is there any legal obligation to respond back to Post?
Well, if it's related to a matter of serious misconduct, there is within regulations, specifically 1205, parent A, parent 8, that an officer needs to cooperate with an investigation. Failure to cooperate could potentially lead to a violation or of a serious misconduct, but it doesn't supersede an officer's constitutional right acting under advice of counsel. So, for example, if the officer has a pending criminal matter and they're under the advice of an attorney not to give a statement, it may not necessarily apply. And post would never use it as a mechanism to end run an officer's constitutional right.
Bill, any updates on streamlining the submission of complaints and subsequent document requests?
Currently, no. Currently, no, there's nothing in the works to update or streamline the process as it's laid out now.
Okay. Kevin, next question. What is the evidentiary standard for moving forward in the decertification process?
The statute sets forth that the standard is clear and convincing evidence. Clear and convincing evidence is defined as the allegation is highly probable to be true. And so that's the definition that we're using. It is higher than preponderance of the evidence, which is used in employment law and in the internal affairs investigations. And it's less than beyond a reasonable doubt standard, which is criminal.
Okay, Marcus, what is the process for civilians who are using the post-decertification process to make complaints against peace officers?
Civilians can either walk into post and file a complaint against an officer in person, or they can go onto post website and fill out a complaint online and submit that complaint to post. Post will then take that complaint and submit it to the agency to investigate that before post takes a look at the investigation.
Okay, Brandon, I think you kind of referred to this, so I'll ask you this question. Please provide clarification on the 8th serious misconduct allegation, failure to cooperate. What type of investigation does this refer to?
So it refers to allegations of serious misconduct. And we already spoke about the officer has the right to, they have their constitutional right if they're under the advice of attorney. All those things would be taken into consideration, but it really applies to allegations of serious misconduct in a officer or a subject officer failing to cooperate as a result of that investigation.
Okay, Kevin, I'm going to ask you a question that just came in the live chat. Is there any tolling that applies if there is a criminal matter pending while the post investigation is underway and an officer's statement is requested?
Generally speaking, we will toll our investigation pending an internal investigation or during a criminal investigation. We don't want to interfere with the criminal investigation, and so we will, generally speaking, allow those investigations to proceed until we take our look at the allegations.
Okay. Bill, do commissioners and board committees members discuss with each other SB2 matters?
So the board or the commission, taken separately, they're under the umbrella of the Brown Act. They have agendized, posted agendas of their meetings. The topics that they discuss at those meetings are part of that agenda, and as such, after a case has been presented to the board, they can then go back in a closed session and have a discussion with each other. They can obviously discuss it openly as well, but they can go back and have a discussion under a closed session with each other about that specific or anything that's on that agenda. They're not talking about things that aren't on the agenda. They're not talking about things, the board members are not talking to the commission members and back and forth. So yes, they can have a discussion under certain parameters.
Okay, I know that our Assistant Executive Director, Anne-Marie Delmanaya, would like to just make a comment on that also.
Thank you, Bill. You've got that. I just want to clarify, the commission and the board is under the Bagley-Keene Act. And by virtue of that, all of the discussions have to be held in a public forum with the exception of closed session discussions, which is what Bill was referring to. 2 members may actually have a conversation about kind of the merit of a case, but members should not discuss the actual decision-making authority of either the board or the commission in groups. That's considered a serial meeting, and it's outside the public transparency. So again, all of the decisions, all of the discussions, the case deliberations have to happen in a public forum.
Okay, thank you. Marcus, are use of force experts consulted with when reviewing an incident by post, and are they third-party affiliates?
Short answer is they can be. Post does consult with use of force experts related to a use of force investigation. We do not always consult with the use of force expert. So it's case-by-case basis.
Thank you. Brandon, what do you do when the city attorney tells admin the violation is not SB2 reportable, but you think it is?
Organizations may have some internal debate as far as how they want to proceed, but the organization needs to make a determination if it meets serious misconduct or not. And any matter that is an allegation of serious misconduct that could lead to decertification needs to be reported to post. If there's those gray area considerations, we strongly encourage an agency to report those to us so we can take an independent look regardless.
Thank you. Bill, does each agency provide post with their current investigation once they are completed? And if so, do they provide recommendations for decertification?
Yeah, that's one of the things that we questioned about tolling earlier. That's one of the things that we wait for. We wait for the completed investigation from the agency. Once they've conducted their investigation, that's what we start with, reviewing their investigation to make sure that that it's complete and thorough, and then we work off of that. So yeah, they're required to provide it to us. Sometimes we have to ask for it. Sometimes it doesn't come in automatically, but they are required to provide it. I haven't seen an agency make a recommendation on decertification as part of their reporting. It wouldn't matter if they did. We make our decisions based on our investigation and our follow-up to their investigation based on the evidence that we locate and not what the agency recommends.
Okay. Kevin, I'll ask you a question that came in through the live chat. Can the board take action against an officer's certification for a finding by the employing agency of serious misconduct if the finding is subsequently overturned by an appeals body?
The answer is yes. So a couple of things. First of all, in the question, it said, can the board take action? The board makes a recommendation to the commission, and the commission is the ultimate final determinator of the action against a certificate. The post-staff investigators, all of us here, conduct an investigation that is completely independent of any internal investigation or a criminal investigation that's ongoing. If there is clear and convincing evidence that sustains, that is to say that it is highly probably true that the allegation is accurate and true and sustained, then we can bring that case forward. So even if at the employment level, there is a later arbitration, there is a later writ, there's a later reinstatement of the officer, Post has an independent relationship with that officer based upon the license that Post is issued to that officer, and Post can seek the revocation or suspension of that through the decertification process.
Thank you. Marcus, if a peace officer is injured off the job and deemed unfit to meet the physical requirements of the position, can the officer be decertified?
An injury or not meeting physical requirements does not fall under serious misconduct, so the answer is no.
Brandon, does post review override the findings of local law enforcement agencies?
Yes, the ultimate decision would be up to Post, ultimately the commission after hearing a matter, but yes, it does as far as the short answer.
Okay. Bill, what are the repercussions for an agency that misses the 10-day notification?
So Sorry, agencies have a legal obligation to make that report under the law. And if an agency fails to meet that obligation, there are some legal actions that can be taken against the agency to compel compliance. And that is an option available to Post.
Kevin, what steps in the process does an officer have a right to be heard or defend themselves? Are they entitled to representation at those stages?
Officers obviously should feel comfortable getting representation at any stage. When I talk to officers, I recommend that they get representation or talk to somebody as early as possible. They have a right to be heard and defend themselves at any point during the process. On our side, we will notice an interview, and that notice is a formal process that is set forth in Post Regulation 1206, and we will provide that opportunity to the officer. POBAR does not apply to our investigations because we aren't the employing agency. We will apply some of the concepts that are in POBAR to our interviews and our investigative steps. Subject officers, as well as witness officers, have a right to bring a representative, so long as that representative is not a party to or a witness to the same allegation. So at what steps does the officer have a right to be heard and defend themselves? At every single point. There's a formality to it, and that formality is once the officer is noticed with the interview. Are they entitled to representation? Yes. And we have seen many officers who come in with counsel, and that helps alleviate some of the stress, I think, on their side.
The other question we get also is if you're called as a witness officer, are you allowed to have representation also?
You can, yes.
Yeah. Okay, Marcus, what is the process when an officer has had his or her certificate placed under review? And is the officer advised when the review process is complete if no action is taken?
An officer, if placed under review, is new to me, but if their case is submitted to Post, Post will conduct their investigation into the misconduct, and if they are cleared and the case is closed, the officer will be notified that the case is closed with Post. And maybe Michelle can answer as far as under review. I'm not aware if there's anything on the website.
I don't believe under review is one of our official terms. However, as Marcus stated, the officer is advised usually at every major step of the process of where they stand and where their certification stands. So hopefully that answers the question.
Yeah, I think just the follow-up on under review, I would assume that the person that asked the question means under investigation. So do you want to clarify anything else after that?
Yes, the officer is not always going to know that Post has their case. That's dependent on the agency and the LEC handling the case. If he believes that case has any kind of merit to warrant notifying the officer that they believe that this case may go before the advisory board or the commission, we will send the letter of notice of investigation to the officer. And they will also get the letter when the case is closed.
Okay, I'm glad you brought up the notice of investigation letter. So Brandon, can you explain what a notice of investigation letter is?
Sure. The notice of investigation letter, as is mentioned just previously, if it looks like there's a case that may have merit moving forward, a notice of investigation letter is mailed out to the subject officer. Included in the letter is just general information regarding serious misconduct and SB2, and the contact information of the law enforcement consultant that is assigned their case. It may also include the voluntary surrender form as well.
And Kevin, does the agency get notified when an officer receives a notice of investigation letter?
No.
Bill, what are your options if you receive a notice of investigation letter? if you're an officer and you receive it? What are some options that they have?
Well, there's really nothing that they need to do. They can certainly reach out, as Brandon said, the law enforcement consultant that's investigating their case, their name and phone number will be in that letter. They can reach out directly to that LEC and ask if there's anything that the LEC would like to know. Is there any information, or would they like to talk to the subject officer at that point? No obligations. So options, yes, you can contact them. But unless you receive notice that from Post that Post intends to send your letter or send your case for review at the board level, there really is nothing to do but wait for some notification from us.
Marcus, we have a question that came through the live chat. Can an officer go back to work if an IA was unfounded, or does he have to wait for Post to finish their investigation?
An officer can go back to work if the internal investigation cleared them. Yeah, Post will conduct an investigation independent of that.
Kevin, the next question is for you. Has anything changed for the decertification process regarding sustained IA excessive use of force findings that are not being filed by the DA's office?
Nothing has changed from Post. It should be on. Nothing's changed from Post's perspective in terms of how we do the intake, the processing, the triage, and the conduct of our investigation. So in other words, when I say that, what I'm saying is if we get a complaint, charge, or allegation of serious misconduct that involves use of force, and we know that there's a criminal case that's pending, typically, as I said earlier, we'll wait for that criminal case to finish out. Then if it's prosecuted and there's a successful prosecution, and if it's a felony or one of those misdemeanors that's in Government Code 1029, then the case will be resolved if it goes down that path. If it doesn't resolve that way, then it's on the LEC, the law enforcement consultant, to conduct an investigation of serious misconduct and make a determination whether there was whether there was clear and convincing evidence that there was physical abuse, including but not limited to unreasonable force or excessive force. And if there was, are there reasonable grounds to bring the case forward? So then we would pursue that, go through our internal processes, and if approved, then potentially, if it was to move forward, a notice of intent to revoke the certificate would go out.
Okay, Brandon, I have a question through the live chat. Where Post is interacting with the subject officer, for example, with the letters, interviews, et cetera, how much transparency information is shared with the department?
There may be some interaction shared with the department, but it really involves the subject officer. The interaction with the department is if there are follow-up documents that are needing to be received. So we might reach out to the department for those documents. But the interaction is really with the officer that's the subject officer related to the investigation. However, there might be circumstances where there's such as a immediate temporary suspension that's been served on the officer. And that might require some communication back and forth with the assigned law enforcement consultant and with the agency.
Can one of you maybe follow up a little bit? You mentioned the immediate temporary suspension. What is being sent to the agency? Can anyone comment on that?
Go ahead.
Yeah. The agency gets a notification through a letter that that they're the subject officer, based on one of the requirements that Brandon was talking about. If we have determined through our process that it's in the the best interest of the public safety and welfare for that officer to have their certificate immediately or temporarily suspended while we conduct our investigation, we will send a notice out to that officer, to the agency, and also to the district attorney's office in that county, letting them know that that subject officer's certificate has been temporarily suspended while we conduct our investigation.
Okay. Anybody want to add anything?
I think one of the things that's important is this Post regulation that deals with the address of record. and I still don't know what the figures are. Maybe Michelle can weigh in on this, but we aren't at 100% compliance on the address of record. And so it's imperative for post to provide due process to the officer. That is to say, the officer can get notice of any regulatory actions against the officer to be able to have that chance to appeal. And so we can't do that if we don't have an address of record. And so I would just encourage officers out there to go onto the PostPass website and fill out an address of record.
Let me follow up on that real quick. Kevin, as of the last time I ran the statistics or had the statistics run, back in March, we are barely scratching 15% response rate on that. Just as a reminder, as Kevin said, it is a requirement that peace officers provide us or designate an address of record that can be your agency's address. Just be aware that if you work off-site or at a location that's not headquarters, that's where the mail is going, is to your headquarters address, what we have. You do have the option to designate a personal address, a PO box, or if you are working at a non-headquarters location, you can, again, designate an off-site address and put that address in that box. But it does behoove you to provide us with an address of record, especially if you are separating, whether it's retirement. You are actually required to provide that to us for up to 3 years after you separate, so that you can make sure you get this important mail from us in a timely manner, because there are deadlines for responding to some of our notifications. You can also designate an alternate email address for communications that way as well.
Okay, Marcus, we have a question that came through the live chat. This topic of address of record, can the agency training manager / EDI admin person enter it in for the officers? I think that might be a Michelle question, but
Yeah, per Michelle, the answer is no. An officer needs to take it upon themselves to go in there and enter that information.
you know, we did add information on that site to say that whatever address you put on there, it's not PRA-able. We did also add an option for you to put a phone number so that we can contact you. So it's not something that can be releasable also. So next question goes to Brandon. Concerning internal-only investigations, can lying, omissions, falsifying memos, or misrepresenting facts be grounds for decertification?
If it's related to the allegation of serious misconduct, then yes, it can.
I'm going to jump over to a question that came in for Holly. How do we process anonymous public complaints that are forwarded to our agency to review when they are too vague to follow up and no contact information for the complainant is provided?
Okay, so if you receive a public complaint from us, and everything is very unspecific, there's no specific incident that you can locate or the specific officer, we'd ask that you respond by submitting an agency supplemental to that public complaint within Mark 43. And inside the agency supplemental report in the narrative part, please just indicate your reasoning for that purpose. If additional information is needed, we will reach out to that specific agency and work closely with them. We're always available agencies through Mark 43. We can be reached at complaintintake@post.ca.gov.
We've got a little plug in there. I like it. Okay, this question's a little lengthy, so I'm going to read it and then I'll ask whoever panelist wants to take it. During an IA investigation into false statements made during an administrative interview, the subject opts for a medical retirement. At least one allegation of providing a false statement is sustained. As the precipitating event was false statements during an administrative investigation and not a criminal investigation, would the department be required to report that to post as an SB2 violation? Kevin?
I can take a crack at that. The Statute says that the agency has 10 days to provide a report, a complaint, charge, or allegation of serious misconduct that could potentially render a peace officer subject to revocation or decertification. So in this scenario, Post would have already received the report of the complaint, charge, or allegation of dishonesty. And even if it didn't and it later occurred, then Post would receive that information from the agency by way of the Mark 43 submission, and later the agency would communicate with the Post investigator to get the completed IA report. The question seems to focus on that it is not a criminal investigation. It doesn't matter if it's a criminal investigation or not. If the agency was conducting an investigation of dishonesty, and if that dishonesty falls within that could render a peace officer subject to decertification, then it should be reported and Post would get that information.
Okay. Next question for any of you to take. What types of use of force cases with adverse findings will result in decertification? Brandon?
Shot. Well, those that are specifically as defined by serious misconduct, so excessive force, but please keep in mind when we receive these cases that involve use of force, it's not looked at in just a narrow scope. We're dealing with situations where we know it can impact a subject officer's livelihood. So anything that involves an allegation related to use of force, oftentimes, if there's any question to it, we will do a peer review amongst our individual bureaus. And for example, if everyone in my bureau is in attendance, we're looking at the collective law enforcement experience of approximately 200 years, or close to 200 years, which is a little depressing to say. But it really is important for us to get the viewpoint of objective reasonableness, and the law enforcement consultants are well in tune with case laws such as Graham versus Connor, and looking at the totality of the circumstances and having those discussions. And then if there looks like there's merit, then proceeding forward. So use of force, although it's a broad definition by regulation, because it could be excessive force, that it doesn't necessarily equate to every push or shove.
I'd like to follow up on that. Each case is analyzed individually here at Post. And so we answer 3 questions when we get a case assigned to us. Those 3 questions are, is there clear and convincing evidence that the allegation would be substantiated, that use of force, the physical abuse, including but not limited to unreasonable or excessive force? Number 2 is, does it meet a definition of one of those 9? And then the number 3 is, are there reasonable grounds? In the licensing world, the certification world, we're looking at the holistic picture of that officer, the officer's training, the service record from the inception of that officer into the profession of being a peace officer onward throughout that officer's tenure with their department. And so what we're doing is we're looking at that from a licensing perspective to see, is it in the interest of the public health, safety, or welfare in order to seek a revocation action against that particular officer, given the yes answers to, is there clear and convincing evidence that the act occurred? Is there clear and convincing evidence that it violated the statute? And are there reasonable grounds? So that's the context in which we're looking at each one of the cases that Brandon's talking about once it goes into the process.
Yeah, and I just want to comment, like, if the case goes to a board hearing, can either Marcus or Bill comment on what should an officer expect if their case goes to a board hearing or a commission hearing? What's the expectation for the officer?
Well, expectation, I mean,
I guess my follow-up question would be is what are they allowed to say, or what are they allowed to present there?
Sure. So as we talked about a little bit, and I forget who fielded the question, but we talked a little bit about what are the officers' abilities to not only speak on their behalf, but can they bring counsel? The board hearing and the commission hearing, if there's either of those, that's a perfect example of when the officers not only allowed to speak on their own behalf, but can bring counsel if they would like. Both of those hearings have a public comment section that's in the agenda. And under that period, under that portion of the agenda, the officer is allowed to make their comments. It's not like court. It's not like going to court where your attorney asks you questions and you answer them in front of the board like you would in criminal court in front of a judge or jury. It's really just public comment where the almost free flow where the officer and or their representative can make comments about the officer and or the case. But there's not a Q&A session involved with that. It's just more of a 3 minutes of pleading my case. When it gets to the administrative law judge portion, I haven't been there yet, so I haven't had to sweat that one out yet. But that one, my understanding is a little bit more like a court case where the attorney is asking the officer, subject officer, specific questions, and they're allowed to answer. And it's more like going to criminal court. And maybe somebody from lab can elaborate on that for me. But that would be an option for the officer at that point.
Sure. So I'm happy to follow up on that. So the process of the part of the process that is an evidentiary hearing is the process that occurs if the commission has determined that there is serious misconduct warranting an action against the officer certification, and the case is then remanded or sent back to the division to initiate a legal proceeding against the officer's license. At that point, the Attorney General's office will prepare what's called an accusation. That accusation is served upon the officer, and then after a period of discovery, there is a process that takes place before an administrative law judge, in which testimony is given. People can be examined under oath. Evidence is formally admitted, and so that is more like a proceeding that you would have in court. That doesn't occur in the initial stage of the process, the very first hearings that happen before the board and before the commission. That really, under our statute, is just an opportunity for the board and the commission to review the investigation that our law enforcement consultants had put together and to make a determination if there is enough evidence for it to be sent for the full administrative hearing. So in those initial proceedings before the board and before the commission, under our statute, there's no opportunity for cross-examination, presentation of witnesses or evidence or anything like that. Our LECs simply present the case as they found it, and then the officer and the public have a right during the public comment period to comment.
Thank you, Toby. Okay, Marcus, do agency policy violations amount to serious misconduct, or is there a difference?
Most of the cases that Post receives all in some form are a policy violation, whether they are excessive use of force or dishonesty. So Post gets the cases based on the policy violations. So those policy violations may rise to serious misconduct where Post will investigate that case.
Or they may not, and we close it.
Correct.
Okay. Brandon, what if the officer is terminated for a policy violation? Is that automatically deemed serious misconduct?
Not if it isn't related to serious misconduct defined by Commission Regulation 1205. So an agency still has their discretion to take administrative matters into their, lack of a better term, into their own hands or render their own decisions for their internal policies. Post only looks at serious misconduct related to certification related to the subject officer's peace officer certificates.
Okay. Kevin, can you just talk about if an officer receives a closure letter, can they still be, how could that come into play as far as future cases that are reported to Post? Can Post use those other cases, even though they're closed, in a current case that they receive?
There's a potential that the previous allegations could come into play in any future allegations of serious misconduct. And the reason why I say that is because of what I said earlier. We're looking at that holistic picture of the officer, the service record, the training record, the activity of the officer, other misconduct. And so earlier I said the third question, are there reasonable grounds? So we can look to, and the commission is mandated to look at post-regulation 1213, which sets forth aggravating factors and mitigating factors. And so those aggravating factors might be a pattern and practice of previous misconduct. Mitigating factors might be whatever they are. We've seen some chemical dependency cases and officers who come in and say, hey, I was an alcoholic or something. And so they want to use that as a mitigating factor. So those previous cases could potentially come into play in any future serious misconduct case.
And how long are those records retained, Bill?
You had to pick me. I have no idea.
Marcus?
30 years.
A long time. Okay, Bill, I'll give you another one. If I have a case pending with Post, can I still be hired by another agency?
Well, the answer to that is it depends on what type of case you have pending with us. If we've done an immediate temporary suspension, then your certificate is suspended. If you don't have a certificate yet and you're still working with your proof of eligibility, that can also be suspended. And just because you have a case at Post doesn't mean that it's currently under investigation. You might have already been cleared by your agency. You might have a case with us that Post may not move forward. And under those circumstances, there wouldn't be any hold on your certificate from Post to keep you from testing with another agency.
I'm going to ask a question for Michelle that came in. My recollection is that an officer's Post profile will show allegations of misconduct. Is there now, or is the commission considering a mechanism for officers to challenge and remove allegations from their Post profile?
Yeah, I think there may be a misunderstanding as to what is actually on a Post profile. So the Post profile actually only shows the peace officer's current certification status. So it would be active, inactive, temporary, immediate temporary suspension, a suspension if that's what the commission renders as a decision, revocation, and ineligibility, and a disqualification. Ineligibility is if they have a conviction that's identified in Government Code Section 1029 after January 1st, 2022. A disqualification would be for the same, except that it is prior to January 1st, 2022. Those will show on your Post profile. If a temporary suspension is withdrawn, then that will come off of your profile. But there will be a footnote on your profile. So if you scroll down to the bottom of your profile, that will identify that your certification was suspended for a period of time and specify what that period of time is. So I hope that answers the question. Your serious misconduct allegations do not go on your Post profile, only the status of your certification.
Thank you, Michelle. Okay, I'll open it up to the panel. If I am the subject officer under investigation, can I get a copy of the Post investigation report?
If the case is moving forward, that is to say, if an officer receives a notice of intent to revoke the certificates, then it's been our practice to provide a copy of the report and attachments to the officer as part of, I think, a policy consideration to say, hey, here, take a look at this. This is the case against you. Do you want to fight it? Do you want to submit the appeal, so to speak? If the case is closed, we have not made those public at this time.
Okay, I just want to make a last call for any questions through the chat. Those were all the questions that we received that prior to the panel. So, and any live questions that we may have, I'll just give it a few seconds. Otherwise, this session is recorded and will be put on our website within the next couple weeks. So if you want to watch it over again, or if you want to send it to other folks in your agencies, it will be available. Oh, Katie's handing me the Post website location of it. It'll be under the www.post.ca.gov under the decertification section. Also, there is all of the consultants in whatever bureau that they do work, all of their information is on the website. So if you ever have a question about a case or any information that you need, all of their contact information is on the website. And it looks like we are clear from the live chat. So thank you for attending. Thank you for the panelists and all the other members of Post that assisted. And we look forward to seeing you at the next one. Thank you.